If a story is in the public domain, you do have the ability to read it on a live stream or on your social media. But if that public domain story has been reprinted by a publisher in the recent years, are you legally allowed to read that new republished version without getting into any copyright infringement territory? Let's talk to a lawyer to find out.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called The IP Professor that is dedicated to all things intellectual property.
Tony, we've been talking a lot about whether or not we can legally read books on YouTube, on social media, in live streams, and we've got some really great videos that I'm linking down below in our caption. But we did have a follow-up question come in from some people asking about stories that are in the public domain but have recently been printed by a well-known publisher. Are they then allowed to use these reprints in their YouTube videos or their live streams? Can they show the artwork? What's the legal side of this?
So this is a really great question, and I hate to be that lawyer that always gives this kind of answer, but I'm gonna have to say it. It really depends. It really does, and I think the facts of every single fact pattern of the sort are going to vary. But this is what I would say: the book itself, the actual story of the public domain story, that's in the public domain. That's free of copyright. There is no issue reading that story. Where it becomes a little bit more chaotic and probably a little bit more like iffy is if, let's say, the republished version of a book contains maybe like some additional things that were never before published from a manuscript of the book, or features illustrations or animations that have never been done before. They were uniquely made just for that publishing. So a great example that's coming to mind is, let's say, Winnie the Pooh. Obviously, the original A.A. Milne book has very specific animations of Winnie the Pooh and all of his friends. That original version of the book that was published way back in 1922, that is free and clear under copyright law. That is totally fine for use because that's entered the public domain. But let's say HarperCollins or Scholastic or Penguin or Random House or any of these other major publishers decided to take that book, republish it. Maybe there's some additional things that the A.A. Milne estate uncovered that they want included in this republished version of the book. And on top of that, the animators at the publishing house want to do a different animation, a different illustrative take on what Winnie the Pooh would look like and all of his friends. That new illustration, first and foremost, is a new copyright. That is going to be protected under copyright now for a duration of 95 years from date of publication. So that's going to be actively protected, no ifs, ands, or buts. The republished version of the story itself will contain some new elements that are likely going to be protected under copyright, especially if they've never been published. But there is a world where if the original publishing house had access to older versions of a manuscript, there actually may be a world where the 120-year term actually governs. And under copyright law, at least the most recent rendition of the Copyright Act of 1976, works of authorship that belong to a corporate entity, aka a non-individual, last for 95 years from date of publication or 120 years from date of creation, whichever is first. So for something that is unpublished, actually that 120-year term is what's going to govern over the 95-year term because it was never published, it was never seen before, but it was created on a date and does have some type of vested copyright interest so long as that term hasn't expired yet. So either way you slice or dice it, it could get a little dicey. And this is the more common sense rather than legal answer that I would give anyone. At the end of the day, you're talking about publishers and their autonomy and their power over the works that they put out there. They could do anything at their will to take anyone down because they view themselves as a juggernaut, as a corporate machine. So if you read a book, obviously with the conviction that it's in the public domain, you're better off reading the original published version that was published way back when, that was in the public domain, and showing those versions of the illustrations rather than reading a republished version of that public domain story with newer animations. Because what's going to happen is the publisher is not going to care about your story of, oh, it's in the public domain. They're going to view their work as something protected under copyright. They're going to go after you and send a cease and desist, telling you to cease all readings or viewing of their works of authorship, any public display or public performance of it, and they're going to go after you potentially for copyright infringement. You're better off just using the kosher public domain version rather than the republished version. And obviously, if you have any questions about that, or if you do want to read the republished version of a story and you want to go about it the right way by way of a licensure, go speak to a lawyer. They can help you get all the necessary questions answered, and obviously help create the roadmap for you of what that would look like to get some type of public performance license from a publisher.
And of course, if you have further questions on this or spin-off questions, now is the time to drop those down below. Tony's coming back for upcoming episodes. This has turned into a multi-part series here because you're bringing such great questions in our comment section. So go ahead and drop those down below, and anything about the legal side of the publishing space. And always make sure that you are reaching out to Tony on his social medias as well. Tony, where can everybody find you?
You can find me on Instagram, YouTube, and TikTok at the IP Professor, and you can check out my entertainment law podcast called End Scene, with new episodes dropping every Friday on Apple Podcasts, Spotify, or wherever you listen to podcasts.
Drop your question on the legal side of the publishing industry, and follow along for daily videos helping you navigate the world of writing, publishing, and marketing to make this your most profitable year ever with the least amount of stress and overwhelm and time commitment on your content creation. We'll see you in the upcoming episodes.